Hey there, Scott Shoemaker here. I am an estate planning attorney in Cedar Rapids, Iowa. And one of the questions that I oftentimes get is, if I don't name guardians for my minor children, what happens? And the fact of the matter is, naming guardians for your children is really, in my opinion, one of the most important things that that parents can do to make sure that their children are cared for in the way that they would have them be cared for in the event that something really terrible happens to you, to mom and dad. But at the end of the day, there's a mechanism for this, and typically what happened is that if there are no guardians named, or there are no suitable guardians named in your will or in other documents, a judge would be charged with finding a guardian, an appropriate guardian for your children. So this is basically like the foster care process. And so typically a judge is going to look for family members. If there are family members nearby, they may turn to friends if family members are not available or not suitable for various reasons, and then they could ultimately turn to strangers if in the absence of any guidance. Of course, sometimes judges are called upon to make very difficult decisions. If you have lots of family nearby, you may have many family members come forward and want to be the guardians of your children. And sometimes those motives are altruistic, and frankly, sometimes they're not. And a judge may have to make a call based on an incomplete understanding of the facts. They may have to decide that one person looks way better on paper, but that's not the person that you would want to have raise your children. And so it puts them in a very difficult position. So if you don't name guardians for your children, ultimately a judge will make that decision.